Good evening. Today we're going to discuss about the Biden administration withdrawal of the H-1B regulations that would have put a lot of restrictions on the specialty occupation, employer-employee relationship, and third-party placement. It would have made very difficult had these regulations become effective. Though we're going to discuss about that. Thankfully, it's been withdrawn. We're going to discuss about what options you have if you're nearing the 6 years of your H-1B limit. What do you do about it if your I-140 is not approved? We all know that unless the I-140 is approved or PERM labor is pending for more than 1 year, you can't extend the H-1B beyond the 6-year limit. What other alternative options that you have? We're going to also discuss about the travel ban update. As you already know that about 2 weeks ago, Biden administration has put a ban because of the pandemic, what's going on in India. We're going to discuss more about that. We're also going to discuss about I-485 processing, also called as adjustment of status processing. How is the USCIS processing the I-485 or adjustment of status applications, particularly the applications that were filed in October of 2020? I just want to point out, we do get a lot of comments on it. We are not YouTubers, guys. That's not our profession. Neither me or Emily or any in our office, we're not YouTubers. We do occasionally. We do spend about 2 hours or so. I spend on YouTube and Emily spend an hour or so. We have a good team that help us in organizing the things. We have a big law firm of about 16, 17 lawyers plus about 80 or so, 70 or 80 support staff that you have. We are practitioners. We are immigration law practitioners. We are not just giving speeches here, but we do immigration practice. We do have in-depth knowledge and we have understanding, and we do cases personally ourselves, not just speak on it, but we do cases. We have exposure within our office that also brings us more things to you guys rather than just speaking. We do actual filing of the cases, RFEs. We do see the rejections from other law firms, and not just other law firms. Sometimes it might be from our office too. So we have a practical experience. That is our main experience, not YouTubing. I just want to point out that. Emily, what's going on Biden administration though? I mean, did he withdraw by itself or what happened?
Yeah, this is really much ado about nothing, because this regulation was actually already blocked by a court all the way back in December of 2020. This goes back to all the way to October of 2020 when President Trump at the time, his administration issued an interim final rule. They skipped the whole rulemaking process and went straight to an interim final rule, basically saying that the COVID pandemic made them do it. And because of the pandemic, they couldn't spend time going through the whole administrative process to pass the rule correctly. This regulation would have changed the definition of specialty occupation, changed the definition of employer-employee relationship, and put a lot of restrictions on third-party placement. If you remember, they were going to limit approvals to 1 year for third-party placement, and also require the third party to file an LCA and an H-1B petition, all kinds of crazy things, increase site visits. All of that was blocked by a court back in December because they said the pandemic was not a good enough reason for the Trump administration to skip the administrative process. So really all that happened with the Biden administration is just implementing what the court said by passing or publishing a final rule that basically vacates the old regulations. So now we're back to the pre-October 2020 regulations in the Code of Federal Regulations, the actual book of all the laws and regulations that we've got for immigration. So not really any big change, really just implementing something that was already blocked by a court for the last 6 months.
With regards to the 6-year option where people are limited because their I-140 is not approved and their pending labor is there are multiple different options that we want to suggest people to. One of the options, of course, if they have a H4, that's one thing they definitely need to go for. There is also option that if they can spend time outside the country, and people have skipped, I can't go to India because I don't have the H-1B stamping in the passport. Well, there is an exception that if you go to Mexico or Canada and you stay there for less than 30 days, you can come back on a valid H-1B, which has an I-94 attached to it, you can come back without having a stamping. That's called automatic revalidation. I want you to check it out on our website at rnlawgroup.com. This is option. I mean, there are some people that I suggested, hey, you know, go spend there 25 days and come back. Maybe by the time your I-140 is approved. There are ways that people have spent, went there for 25 days, came back, went there for 25 days, came back. Those are the options that can be done. Now, under the pandemic situation though, there are people, lawyers that have suggested that if their 6th year is expiring, they can't go back to their home country, especially if the home country happens to be one of the things that got hit very much with the COVID. You can apply for a B2 visa for you to stay in this country. In the interim period, if your I-140 is approved, you may try to convert B2 into H-1B. We have seen some success in it. There are some times where the officers have not given the I-94, in which case you will have to go outside the country to get the stamping. So those are some of the things that I can think about where you can extend the life if the PERM and I-140 is not getting approved. You may want to consider all these things. The suggestion that I do have to a lot of people is that don't come to our office at 5 years and 10 months and make an appointment with us and find a solution, Rahul. Oh, what am I going to do? I'm not a magician to bring something out for you. I'm not God, I'm not magician, I'm just a lawyer. So I would suggest that you consult any lawyer to have alternative options if your labor certification is taking a long time. Yes, previously we used to think that labor certification, the entire process used to take only 1 year, but right now the prevailing ways, the amount of time it's taking, for the PERM approval, the amount of time it's taking for the I-140 premium processing, which used to be only 14 days, but it's taking a longer time right now, are taking a significant amount of time. I would say at this point of time, you should apply it before you enter into 5th year. That's what I would say now. We may have told people 1 year ago that, oh, you should do it before you enter into the 6th year. But now we are telling 5th year. What does that tell you? I would do it way before you enter into 4th year. I may even suggest a lot of people that, yes, green card is an important aspect of your thing. Yes, people have told you that green card is going to take forever for you to get the green card. Now we have things changed. Who expected COVID to come in? I mean, come on, who expected COVID to stay here for more than 1 year? But it did. Because of that, a law that allows the people to, the green cards that are not used in the family immigration are falling into the business immigration. So this is a great time for you to look into the option of filing a green card as early as possible, as soon as possible. The other aspect that I would tell you is that right now, IT is in the greatest demand. Believe me, I get a lot of these people who are their priority date is about to become current, and they are getting offers like $200,000 more than their offer. Like, man, I'm telling them no, and I'm thinking myself, maybe I should apply for the job. No, I'm not eligible for it. But anyway, these are very nice offers. So this is a right time, even though it's COVID, things are not doing very good. In the IT sector, things are showing good, very good. If your company is not going to file a green card application, they don't like you. Can you not get it? If they are telling you to wait for 2 years and they're not going to file you for green card application, they don't like you. Can you get it? If you can get it, try to move to a different company and file the green card as soon as possible so that you don't come to our office at 5 years and 10 months and ask us what the solution is. It's better to do it very early rather than later on. But if it's later on, we do have other creative solutions that you can think about it. You can still come to us, but it's better to plan it way early. Emily, on the travel ban, what happened now? We know that if somebody has a visa, they can still travel from India to here as long as they stay outside the country, outside India, for more than 14 days. Now, people are planning to go to Turkey. I know that Turkey said no, and then now they said Sri Lanka. I have heard some restrictions coming, Maldives restrictions coming. But still, there are other countries that they can go and come back after 14 days. Now, what about the people who have not got the visa? Why can't they get the visa and then travel to outside the country for 14 days and come back into this country?
Yeah, when we call this a travel ban, really it's a visa ban. And honestly, the administration...
Oh, that's not what it said, though.
Right. And then, the administration doesn't have the power to block people from getting visas, but that's practically what's happening. They're using the travel ban that says the president can suspend entry into the U.S. to basically say, we can't process your visa. So it is very difficult for people to get the NIE consideration in order to the national interest exemption from the pandemic. It's practically impossible right now. The consulates are just not operating. They're taking forever to respond to any requests that are being submitted. And people that seem like they should clearly qualify, it's just a flat out denial. We're not going to give you an emergency appointment. We're not going to give you the NIE exemption. And people are just stuck right now.
Have you tried any of those things, Emily, recently on NIE exemption?
Yeah, so the travel ban for some other areas is not new. So we've been working with people in other locations, and basically now, for example, in the United Kingdom, they have information on their website for the embassy in London that says, if you think you qualify, these are the steps to follow. You fill out this form on the website. There's specific boxes with character limits that gives you space to give an explanation. And then after you submit that, you'll receive an email if they think that maybe you might qualify. And there's a very long list of questions. I think there's 30 some or more questions in that email. And then you reply back to that with the supporting documentation. So for example, if you're arguing that your work is vital to critical infrastructure, you need to have a letter from your employer that spells out exactly how you qualify for that, in addition to answering all of the questions in the email. Then you have to wait for someone to decide whether you qualify for the emergency appointment. And if you get the appointment, that doesn't mean you've gotten the exemption. That's just the appointment. They're going to ask you more questions during the interview. They could still deny the NIE at the end of the interview. So it's not an easy process, and because it's so new for India and the consulates there really are not operating, everything's been shut down due to COVID, it's going to be some time before they get plans in place to be able to actually deal with these NIE requests.
Emily, I'm an engineer. I build roads and bridges. Isn't that a critical infrastructure, and should I not be exempt from this one?
I think that there's an argument to be made. There's a set list of things that fit under critical infrastructure, and if you can make a reasonable argument that the work you're doing supports that, you can give it a try.
With regards to the 485, are also called as adjustment of status application processing, though, we are noticing a lot of confusion with regards to the biometrics appointment, though. We have noticed that, in fact, one of a couple of other cases today, Emily, we got a pre-adjudication done where they sent to the National Visa Center where the priority date was not current. Actually, it's going to be current most probably next month, where they said that the visa numbers are not available. It seems that they definitely are working much faster than anticipated, though. But I'm very confused about the biometrics, though. Is that what are they telling that they're taking the biometrics from the old when they filed for the H1s, when they came from the airport? Are they doing it or they're not doing it?
I don't think anybody knows, but supposedly that's what Emma, their little chat bot, is telling people when they ask for an update about the biometrics. They say, well, we were able to reuse your biometrics. And people are thinking, I haven't been called for biometrics since I've been in the US for X number of years. So that would suggest that they're taking the biometrics from either the port of entry or through the Department of State when you went for your visa stamping. At the same time, we have USCIS officials who've stated in court documents that they did not have the technological capability to share biometrics with the Department of State. And so it's very confusing right now. We cannot tell from one case to the next who's going to be called in for biometrics and who isn't. On top of that, people are being called in for multiple appointments. You're getting one biometric appointment that mentions your 485 receipt number and another one for your 765.
Another one for I-131.
Yeah, it makes no sense. I think I don't think they know what they're doing.
We have ran it with the other immigration firms, not just our own law firm. And we posed this question, guys, and guess what we got answers from? We got more questions, we never got our answers from them. So it's very hard to conceive at this point of time if they are using the biometrics. One thing is for sure, though, they are issuing, Emily, RFEs for medicals, though, which is very good. I love it. If the people have not filed the medicals, they're issuing an RFE, which is a good thing. That means that there are two things. When medicals are not filed, they can either request you to issue a medical, request for further information for the medicals. The second thing they will do is that, hey, either you submit the medical right now or you bring it to the interview. They're not doing that right now for employment-based, which is a good thing. I'm expecting that there are not going to be many interviews. And I'm also seeing the pre-adjudication of the cases where they said everything, this has been sent to the National Visa Center and that the prior date is not current. That means it's pre-adjudicated. So I'm noticing very good on the medical front. Biometrics is really nightmare at this point of time to judge how the things are going on. Let's go to the questions and answers. A lot of people have asked the question with regards to, especially if you don't have an I-140 petition, though. Especially the I-140 petition has some critical information that may be required for the lawyers to file your 485 application. I put a link down there where you can go to the USCIS and you can, at the bottom of the link on the YouTube and Facebook, there is a link there. You can go to FOIA USCIS. You can request the petition, I-140 petition copy. It takes only 5 to 10 minutes of you, and I have given the directions how to obtain it. Try to obtain that. It's always good because mostly if you have an I-140 approval, your H1 extension depends on I-140. Your H4 EID depends on I-140. Your 485 depends on I-140. If you move to a different company transferring, you require that I-140. If you want that I-140 data to be ported, you need that I-140. It's not just the I-140 approval. It is the underlying application, what has been filed, that is important. I put a link out there for you where you guys can go it. It's free, it's online, and you should do it. All those people whose I-140 is approved.
All right, going to some questions. Naveen from YouTube wants to know, he's changing employers next month and has a priority date of May 2018. How does this impact my chances of 485 filing if the date becomes a current this October? Well, if the previous job offer is no longer available or that employer is not willing to file the supplement J to allow you to file the adjustment of status based on your current I-140 approval, that means you're going to miss the boat this year because it means your new employer will have to start the process from scratch, new prevailing wage, new recruitment, new PERM process, new I-140, and then if the filing date remains current for you, then you might be able to file the 485, but we don't know. Last year, the filing dates, we could use them in October, November, December. After that, we could not, and we've been using the final action dates. Well, everybody that was eligible under the final action dates already filed. So it's very unlikely that you'll be able to get your new labor and I-140 in place with the new company to be eligible to file the 485 this fall.
Questions with regards to S. Ram from YouTube as his question. Have people who applied in I-485 in October, have they received the EADs yet? Yes, they did. Not all of them, especially those people who filed in the first 2 to 3 weeks. Most of them did get it, but for the people who filed later on, some of them did get it, some of them did not get the EADs as of now.
Debjani from Facebook applied for the H4 EAD under the C9 category and submitted an expedite request and received a response that USCIS is unable to expedite the I-765 because the form I-539 remains pending. And she wants to know, does this really depend on the I-539? Yes. USCIS has made the policy that they cannot approve the EAD renewal until they approve the H4 renewal. Now, they normally do those at the same time, but that does mean they can't approve the EAD first. So if you're going to do an expedite, you have to request the I-539 be expedited in addition to the I-765, and you've got to make sure that your expedite criteria are met, one of the 4 that are listed on the USCIS website. But unfortunately, our experience over the past year has been they rarely expedite any applications, which is why we were involved in the class action lawsuit on this issue.
Shailesh has this question: can I pay for I-140 downgrade if my company refuses to pay for it? Absolutely, yes, you can pay for the downgrade. I've seen some major companies that did that, and that's perfectly legal, nothing wrong with it. You cannot pay for PERM labor, you cannot pay for H-1B, but you can pay for I-140, you can pay for 485 application. And this is one of the arguments that we've been making with some of the companies that doesn't want to spend the money because, hey, I filed your I-140, why should I file again? Well, we know why you should file I-140 again. In that case, please convince them, yes, you can legally pay for the I-140 application, and then if they do this, they don't have to keep filing the H-1Bs for you again and again if you get an EAD through this 485 application. I strongly suggest you propose this one and you should pay for it if the company does not want to pay for it.
Mandeep from YouTube wants to know, do we expect the filing dates to be available again in this fiscal year? So we've had the filing dates since 2015, and usually what we've seen is at the beginning of the fiscal year, we have the filing dates that we're allowed to use, and then they stop letting us use them, and then we have to wait until the following October. So for that reason, generally, I would not expect the filing dates to move at all before October of this year, and usually USCIS does not allow us to use them again unless there are not enough applications being submitted, which doesn't seem to be the case.
Arun has this question. He's working for a CAP exempt H-1B company. If he wants to go through the CAP subject employer, does he have to go through the lottery? I think so, that's a question. Yes. If you are from CAP exempt and you want to go to the for-profit organization, you have to go to the lottery though. Excuse me.
Streeter from YouTube wants to know, his birth certificate is in English, but his name and date of birth and other details are written in Telugu. He wants to know, can we have affidavits from someone who knows Telugu to translate it? Yes, so you don't have to use a translation service. You just have to have someone who's familiar with both Telugu and English prepare the translation and then sign a certification of translation accuracy saying that they are familiar with both languages and have accurately made that translation.
And if you are the person who knows Telugu, you can translate it too. And we have provided the samples of it at rnlawgroup.com. You type birth affidavit, we have provided the samples of the translation notations, all those things are there in the website. Please use those things. We made it very practical for you.
Muthu from YouTube has an I-140 that was approved 200 days ago, and he's planning to move to a different state for the same position. His employer is saying it's not material to USCIS when filing the 485 and can use the old I-140. So it really depends on where the permanent job location is. So if you're temporarily moving to another state during your H-1B time, but the permanent job that you were sponsored for the green card is still in the old location, then the process can continue as long as you intend to go back to that old location once you receive your green card. But if the job is no longer at that old location, that can invalidate the labor certification that supports that I-140, and you may not be able to use that I-140 to file the I-485. So your employer should really check with an immigration attorney, or you can set up a consultation with a qualified attorney to discuss whether you can file or not.
Ram has this question. His passport says he's born in place of birth is Secunderabad, but his birth certificate says it's Hyderabad Municipal Corporation. Will that create any problem? I am pretty familiar with what Secunderabad and what Hyderabad is. Secunderabad definitely comes under Hyderabad municipal limit. That should be fine. If sometimes they question these things about, oh, it's Secunderabad, where is that? People can always go to Google and print those things out and have an affidavit by a lawyer. I'm a proper lawyer for it. The reason is that I'm a lawyer in India also. I'm licensed lawyer in Secunderabad and Hyderabad and also in the United States. So yeah, people like me can give an affidavit saying Secunderabad falls under Hyderabad municipal limit, and they do consider it when people write an affidavit saying that it is in the same municipal limits.
Girish from YouTube wants to know if he can get H-1B stamping done in Canada once the border is open, because he lives in Detroit and has a visitor visa to Canada, and then travel to India and come back after quarantining in a third country. Technically, yes, but practically no, because even in Canada, it's amazingly difficult to get an interview appointment for your visa stamping right now. All the consulates are not operating fully. They're not even operating barely. Some of them are completely shut down. Other than that, most consulates around the world are only doing emergency appointments. So very likely, by the time you actually get your visa stamping interview in Canada, and it doesn't get canceled, you may not need to quarantine anymore in India, because things will be better there too.
Rahul Mehrotra has this question. My wife's last name is listed as my last name in our marriage certificate, but with her maiden name in most of the other location. Is that going to create a problem for filing the 485 application? Answer to that question is, Rahul, no. Approximately about 1 billion ladies in the whole world change their last name. And yes, we have seen their last names using sometimes their maiden names, and sometimes they use their last names. And you'll be very surprised what Emily's name actually is. She still uses her maiden name, but her last name is different. So it happens. 1 billion ladies use, and there is an interchange. As long as you have the marriage certificate, you're fine. Absolutely not a problem. In the 485 application and in some of the applications, other applications, there will be a column. Have you ever used any other names? They can always list the other name, and then they will check their criminal record on that name. It will not cause any problem whatsoever at all.
Barath from Facebook has tried upgrading his I140 downgrade to premium processing 4 times now, and it keeps getting rejected because USCIS doesn't have the original PERM. Can we suggest a solution? Definitely understand it's frustrating, but there's not really a solution to it. You just have to keep filing it. Eventually, it should get accepted. It just is taking time for USCIS to pull that labor certification from your old file and move it to the new, especially with the priority date back in 2012.
Bipa Roy from Facebook has this question. Can you give a breakdown of I-140 processing fees? Each employer is charging differently. Well, Bipa Roy, you have only one employer. It's not the employer who's definitely charging, it's probably the lawyer that is charging. Each law firm definitely has a different rates. What is reasonable, what is not reasonable, typically I can't tell. It may be anywhere between $1,200 to $2,500 is the normal fees people charge for the I-140 processing. That seems to be the normaling. And if somebody is charging you $10,000 for I-140 processing, they actually don't know what exactly they are doing. But if between $1,200 to $2,500 seems to be reasonable to me. But as I said, if the guy is charging $10,000, he doesn't even know what he's doing.
Mishra from YouTube wants to know, how is the I-140 inventory calculated? If I have an I-140 from a previous employer and 2 I-140s from my current employer, one in EB2 and one in EB3, yeah, they count all of them. USCIS does not have a way to keep track of how many I-140s go to one person. So they're not counting the person, they're counting I-140 filings and approvals, which means we have no clue how many people are actually in the pipeline, which is why it is so impossible to predict the priority date movement of the visa bulletins, because there's probably many people out there that have 2, 3, 4 I-140 approvals, and USCIS has no idea.
Emily, there are a lot of people are getting confused about this. They're looking into the data of the I-140 approval and saying, oops, there are so many I-140 approvals there, how are we going to get it? That's a very confusing data. Don't rely completely on it. As Emily has pointed out, and you have been pointing out, there are people who have 3, 4, 5 I-140s though. They all are counted. And guess what, Emily? There is another thing though. What if the spouse has another I-140? What if the spouse has a couple of our own I-140s? Technically, they are only going to use one I-140 application to get the 485. So it's definitely, the data is very misleading. The actual data that we used to have was that at the time when you file the 485 application, they used to give a data with regards to when the priority date of that particular person is when the 485 is pending. However, they stopped giving the data from 2018, June or July, somewhere around that, thanks to the Trump administration. Now we don't have the data with regards to the filed applications, how many applications are pending, what's their priority date. We don't have a data. So relying on the just sole I-140 data is definitely not accurate. And when you study the statements made by Charlie in the State Department YouTube session that he had, he definitely did not rely information on the I-140 data. I'm assuming that he got more information from USCIS, which he is not releasing, and that's how his data, he's interpreting it differently. He's not relying on the I-140. Question that came out there is that AB says, there are a couple of people who are asking that my priority date is 2019. What are your anticipation? Do I downgrade it right now? 2019. That's a tough call to downgrade it. Will I spend that much money? I would put a toss, give the coin to my wife and let her toss it. And if it's head, tails, let her call it. And if something goes wrong, blame her. That's what I would do. Whenever I have doubt, I tell wife, put a toss, call it. And that's what I would do. However, though, I personally, if it is 2018 or before, and if I have an I-140 approval, though, I personally will not give a toss to my wife. I will do the downgrade and have the EB3 approval and EB2 approval, which is already there. I will have 2 tickets for the heaven. Whichever comes in, I'm going to take it. That's what I'm going to do. When it comes to the 2019, I'm going to give the coin to my wife.
All right. Gunjan from Facebook and Shah from YouTube have questions about the H4 and EAD renewals. So Gunjan wants to know if there are any updates on the delays in the H4 and EAD approval. Is USCIS going to start the premium processing for the H4 and EAD? There has been no talk from USCIS at all about starting the premium processing for H4s and EADs, so we're still stuck on that. And then Shah wants to know, if I file my H-1B in premium processing, does it help expedite my wife's H4 and H4 EAD? At this point, it still does not. Now, prior to the biometrics rule, yes, if you filed your H1 in premium, the H4 and EAD got approved in premium along with it, even without a premium fee for the H4 and EAD. However, since the biometrics came in, USCIS actually assigns the I-539 and I-765 to a completely different officer. So the person who's taking care of your H-1B has no idea that there's an H4 or an EAD pending. All their job is to do is to adjudicate the H-1B, someone else's job to take care of the I-539. So they do not keep the file together anymore, unfortunately.
Can we file 2 I-140s at the same time? My priority date is 2016. I will move to a different company. Can I file 2 I-140s at the same time? Absolutely, you can. You can file 2 I-140s at the same time using the same labor certification. We do that, absolutely not a problem.
Gargi from YouTube wants to know, the company's been acquired by another company. I have an approved I-140 with the previous company. Should I start over from PERM when the priority date becomes current? My priority date is May 2015. So it all depends on how the transaction occurred. So if the new company that acquired your old company qualifies as what we call a successor in interest, that means the labor certification remains valid and the I-140 remains valid. However, your new company does have to file an I-140 amendment to show to USCIS that it qualifies as a successor in interest and can meet the ability to pay requirement. Now, if it does not qualify as a successor in interest, then you have to start over from scratch with a new PERM and new I-140, and that needs to be done as soon as possible in order to be able to file the 485.
Jagis, as the question of the day I would call it, at what point is the visa number assigned to the AOS application? Good question. Everybody needs to know that it is when they give you the green card. That means when they grant you the green card, you get the 797 saying your 485 application has been approved. That's when the visa number has been allocated. Remember the thing what we described about 260,000 green cards that are going to come in. That's when you actually get the green card. It's not when you file the I-140, it's not when you file the PERM, it's not when you get an EAD approval, it is not when you file the 485J supplement, it's when you get the green card, that's when the number will count.
All right, Prabhu from YouTube has EB2 with a priority date of October 2010, received biometrics notification, and got the RFE for the medical exam and wants to know if they will directly process the green card by skipping the EAD if my date becomes current. So it all depends on the timing. Number one, when did you file the EAD? Number two, when is your priority date going to become current? The fact that they sent that RFE for the medical has nothing to do with the EAD. The medical is telling you it's good that they sent that because that's suggesting that maybe they're going to skip the interview for you and directly approve the green card. But if you take time to respond back to the medical and they're ready to approve your EAD, then they'll still approve your EAD regardless of how close you are to receiving the green card.
Dave Mundila from YouTube has this question. His priority date is April 2019, EB2 category. Should I start preparing for I-485 application? That's a tough question. What we are doing at our office is that anybody whose priority date is on or before December 31st of 2018, our office is offering a service where we can pre-prepare your application and make it ready. If anybody is interested in, we have put a link there at the bottom. You can click that link and you can provide your information. We're going to send you the information, what you need. We're going to charge nominal charges, and the rest of the charges we're going to do it at the time when we file the 485 application. The nominal charges that we're going to charge initially will be credited towards the entire fees. But we're only accepting the cases if the priority date is on or before December 31st of 2018. We're not accepting people who are in January or after 2019 of January.
Gimid123 from YouTube wants to know, the spouse is on H4 because her H1 maxed out in February. Her PERM is still processing and not yet approved. She has a 485 EAD. I'm assuming that's based on your application, and she plans to use it. Can she go back to H1 after the I-140 approval? So if her I-140 priority date is not current, technically yes, but it's not as easy as it sounds because she can't do it from in the US. Her employer has to file a new H-1B petition that's not subject to the cap. Based on the I-140 approval, she can get a 3-year petition approval. but then she has to exit, get the visa stamped, and come back in order to get back into H-1B status. And with consulates being closed, people being canceled for their interviews, that's where the difficulty comes in, is will she be able to actually get the visa stamped to get back in H-1 status?
The question from Rahul G from YouTube is that what can I do? My premium processing got rejected 3 times. Do you know a solution for it? Rahul, let me tell you one thing. We don't know the solution for it. In our law firm, we have some for I-140's premium processing that got rejected 6 times. If you find a solution, you let us know. I mean, this is a feedback, guys. I mean, we are all exchanging the information sometimes. We have had in our office, we are unable to find out why they're accepting some and rejecting some. I would say about 80% of the premium processing are getting accepted and adjudicated in the proper timing. 20% of them are not. There are sometimes when we refile, they're getting accepted. Sometimes they're not. And we don't know what the solution for it. We couldn't find why they are accepting some and rejecting fine. If there is any update from us on that, we'll definitely present it later on. But at this point of time, we are clueless about it.
Lokesh from YouTube has an emergency need to travel to India for at least a month, is on H-1B, has a valid visa, and wants to know, is he eligible to return under the NIE? Well, the good news is you have the valid visa, but you would have to qualify under one of the NIE criteria, and you'd have to ask the consulate in advance to approve you for the NIE before you can travel. So more likely, you would need to travel to another country for 14 days to quarantine there, and then you could come in without the need of the NIE because you already have the visa stamped.
Sunita Verma from Facebook asks this question. Their priority date is March 2017 EB2. Will it become current in 2021 October, or will it be EB3 current? Well, Sunita, it's going to be very tough for me to judge though, but Sunita, I would be prepared for this. I would want to file the EB3 downgrade application and make myself ready for both. I don't know which one I will be able to file it. But if I were you, I would be willing to spend that money to keep myself available in both options, EB2 and EB3. Then I will be able to, I will also, in your case, prepare the I485 application and make it ready to file on October 1st based on the information of Charlie of the State Department. That is what I am thinking that I would do. That's what everybody should do it. People who came before 2015, guys, I mean, they were expecting the green card, and they filed the green card. They definitely were disappointed that it took a long period of time, but finally most of them got through into the application. Guess what? The people who came after 2016, 17, 18, they never even thought that the green card is going to come for them. Now they're like scratching, they're like, what do we do? Well, it's like this, dog always chases the car tire. When the car stops, they don't know what to do. Not comparing you with the dog, but believe me, I was one of those people who have been waiting for the green card, just like you guys. Right now, you have this golden opportunity. Try to pre-prepare, make yourself ready. If something doesn't work out in October, you will be in a loss, but not at a great loss. But if you happen to, if we were to believe the State Department, their numbers and their statistics, the priority date is definitely expected to move way a lot more.
Vikram from YouTube wants to know, his max out date is July 2022 for H-1B. His prevailing wage request was filed in March of 2021. Is there any cause of concern here? Yes, it's going to be a very tight timeline. We always prefer that the PERM labor certification be filed 1 year before you hit your max out. So you'd be wanting to have your PERM filed in July of 2021, which is just around the corner, but your prevailing wage isn't even in yet. Your company still has to go through the recruitment process and then file. So I don't think you're going to hit the 365-day time period. That means that you have to get your PERM filed and get your I-140 approved before your max out date. And the PERM processing times are also not fast right now. So it's going to be very tight. You should definitely be talking to an attorney about options for recapture time, what other options you have to change status to another visa category in case it doesn't come through in time.
Jaini has this question: do you still believe that 260,000 green cards will be given out this year? I am still hopeful that USCIS will do. I'm still hopeful that they should be able to get it. Especially I'm expecting some movements in the biometrics, the way they use. I'm also expecting that Biden administration is completely different than that of the Trump administration. The second thing is that if by any chance the USCIS does not move forward very fast though, Charlie can do miracles. Believe me, you guys are too young to know this one. That guy can do miracles. One time he got very mad that the USCIS is not moving forward with the adjudication of the 485. All of a sudden, in the middle of a night, he made the entire priority dates current. Believe me, he did it. And if you want to, go back and check that. That was in July 2007. I was still a practicing lawyer. Emily was a practicing lawyer at that time too. She wasn't a partner at that time, but she was a practicing lawyer in our office. Believe me, it was a nightmare. We had to call 911 because the whole clients came in, just flew in. We had to call 911 to control the clients. That happened. I don't know whether you have to say thanks for calling to 911 at the time for Charlie or not. Believe me, he did it. He did. So I don't know if they're not going to use it, but I think so. The Charlie has the authority, can just move the priority dates drastically if the USCIS doesn't behave properly.
Raja from YouTube wants to know, if I go with the EB2 to EB3 downgrade with my previous employer, at what stage do I need to join that company? Is it once my I140 is approved, or can I wait until I have the EAD? Really, the immigration requirement is that you're intending to join that company when you get your green card. There's no requirement that you work for that company prior to receiving your green card. Now, the company may have a different policy on that and want you to join them in a certain time period in return for agreeing to do the downgrade for you. But from an immigration standpoint, you don't have to join until you receive the green card.
Question. I'm working for a company right now which is processing the PERM labor certification. But my previous company has a labor and I-140 approval, while my current company is labor certification is processing. Can I file a 485 application with the previous company? Absolutely you can. No problem with it. You can do so. Can EAD be processed with the premium processing in the 485 application? Unfortunately, not at this point of time. Akshay has this question: EB I-140 priority date is current, biometric done. Can I expect EAD and AP? If the biometric is done though, Akshay, there is a chance, I believe, your EAD and AP will be denied. We're noticing that with some of our clients, when the EAD and AP is not received, biometric is done, and the priority date is current, they're just approving the 485 application and saying that, then they say that, hey, you don't need EAD and AP. Those are the happiest denials that we take in our office. We don't contest it. We are fine with it.
Narendra from YouTube is currently on OPT, already got the H-1B approval for with the change of status for 3 years in premium processing, and now has a job offer from another company and wants to know, can I switch my employer now? There's some risk here. Generally, I would recommend staying with the current employer and filing a transfer of your H-1B on October 1st to join the new company. Because if you switch employers now, it's possible that your old employer will withdraw your approved H-1B, and when that withdrawal happens before October 1st hits, it means you're no longer counted in the cap. and it can cause some issues for your SEVIS record because they may not activated it to allow you to keep going on the OPT. And in prior years, several years ago, we used to file the H-1B transfer before October 1st and request an October 1st start date. And then after a few years of doing that successfully, USCIS started denying, saying we can't approve a transfer for you. You haven't been counted yet because you haven't crossed October 1st yet. So we stopped filing those transfers early and recommended to people to wait until October 1st to file it. Haven't really seen a lot of pushback on filing a little bit early, but there's definitely some risks with changing employers at this critical stage.
Harsha has this question. My priority date is 2015 October. Is it advisable to file a downgrade application right now? I would say yes. Here is the reason though. It's good to test the waters. Does your company actually does a downgrade or not? What are the potential problems that might be arising with the HR, with the legal team? It may be better at this point of time to discuss, negotiate with them to see, and it's worth the investment. If the company says, I don't want to pay, we can offer the payment. If I were you, I would do that. Another question that is coming is that from Harish Manda Paka. This was not a legal question, it's more like a personal question he's asking to me. My priority date is October 2015. Is it advisable to change the company? And that is actually October 2015, and he's saying, I think so, it's EB2. But either way, Harsha, if I were you, even if the new company is going to give me $300,000 and they're going to pay taxes on that $300,000 extra, I am not moving if my priority date is in 2015. I am not moving to a new company, because if I move to the new company, by the time they file the labor I-140, it's going to be taking 2 years. I may miss the boat. You already missed one boat. You don't want to miss another boat.
John Paul from Facebook wants to know how to check if the employer revoked the I-140. So first, the employer can't really revoke an I-140. They can request the withdrawal of the I-140. Then it's up to USCIS to decide whether to revoke or not. So USCIS is the one that does the actual revoking. So you can check the online case status using your receipt number to see if it mentions there that they received a withdrawal request or sent a notice confirming withdrawal. You could ask the employer, but that's a little risky because if they didn't withdraw, you may be giving them an idea that they should withdraw, and they might withdraw now. So the other option is to do a FOIA request, Freedom of Information Act. It's free, takes just a couple of weeks. You can do it online at the USCIS website and get a copy of the I-140 file, and it will show in there whether it is still valid or not.
Rajesh is asking, so should we reach your office if the priority date is before 2018, EB2 or EB3? Yeah, definitely. You can reach our office or any of the other immigration law offices that are processing. It's better to reach out right now, Rajesh, rather than reaching out in September of last year. September, we just closed our office. We only entertained our existing clients, and that too, we were not that efficient. Believe us, there was a lot of delay. Instead of filing in October first week, we filed most of the cases in the last week of October. It was really terrible thing for us, and right now we want to pre-prepare the application, make it ready, and boom, priority date becomes current somewhere in September 24th. We have everything ready. We collect the rest of the filing fees, rest of our fees, put it in the FedEx. That's it. It's done on September 30th or October 1st. That's what we would do. But it's if you go to the end date and you contact the lawyers at that time, believe me, you're not going to get a lot of response. All the knowledgeable lawyers in this particular field are expected to be busy like what they were last year.
Naresh from YouTube wants to know, can we get the birth certificate affidavits from friends or relatives that are present in the USA, or do I need to get it from India only? Yes, it can be from friends or relatives that are in the United States. Anyone, anywhere who's knowledgeable as to your birth can provide that affidavit.
Options about coming. My priority date is not current. My I-140 is approved. It's been more than 180 days. and the EAD is approved, I have a job offer, can I join another company? Yes, you can. But the new company needs to file a 485J supplement. And one thing I want to be very cautious, guys, here. Anybody who's contemplating to change the job after 180 days, make sure that your I-140 is approved. There is some misinformation that is floating around. I am not telling that what the other lawyers are not giving you the legal information. They are just answering your question. Can you move to a different company? They will just answer like a parrot. Yes, you can. But they don't tell you the other part of it, that if by any chance your company withdraws the I-140, as the USCIS comes to know that you moved, they may deny, they may issue an RFE. Guess what? They will deny your 485, and believe me, it's going to be tough for you to get that 485 reversed. Technically, you can still go to the court system. The I-140 should be approvable at the time when you file the 485 application. It should be approvable at the time of 180 days. But to prove that, to prove all these things, you are going to pay through your nose to the immigration lawyer to prove it. And there may be a time where you may be prohibited to work for a period of time. That's going to be a nightmare for you and family. For don't move until your I-140 is approved, even though you completed your 180 days on your 485 application.
Sarah Vonnen from YouTube has a new employer that started the PERM process, has an approved I-140 with a previous employer and a 2015 priority date, and wants to know, can I apply for the I-140 and 485 concurrently if my priority date is current this October after the PERM is certified? Yes, absolutely, you can do that even if you're porting the priority date from that prior I-140. You just have to make very clear, or your attorney, in the application package that you have that prior I-140 and that you're filing concurrently with a new I-140 that seeks to retain the priority date under the regulations from the old I-140. Because if you just file I-140 and 485 with the new labor certification, they're going to look at that labor certification priority date and say, well, this isn't current. So they need to make it very clear in the package what exactly you're trying to do so you can get the case accepted.
Sri Bad from YouTube has this question. My priority date is November 2017 EB2. I have a great job offer. Should I move? No. No, please. I will not move if I were you. Believe me. I have had people, and my consultation fees is very high. They paid $400 to see, just to get a different answer from me. And the guy said, I got $200,000 more job offer. I said, no. Sorry, just because you pay us the money, you won't get any different response than what you're getting. I would not. If I were you, I would not move. One thing I would do on top of it, not only I'm going to lose the money, I'm going to spend the money if I were you, is to downgrade the application right now if you are an EB2, if it's in November 2007. That's me, guys. I mean, believe me, I have gone through the process. I know how it is coming from India to here. I came here on H4. I was a dependent on H4. I could not work. I became a lawyer, but I couldn't work until I got my adjustment of status EAD. So I know the pain, what it is to go. Yes, all my predictions did not come through. Some of them did not come through. The predictions are not good. I don't want you to believe my predictions. I want you to believe Charlie's predictions. I'm not telling you actually, Mr. Bad, what to do. I'm just telling what I would do if I were you, because it's tough. I may go wrong in the judgment call, but this is what I am. And if you're going to pay me or if you're going to listen to me, I'm going to give you advice from the bottom of my heart. That's all I'm going to be giving.
All right, well, I think it's about time to wrap up for today. Thank you so much for joining us. As always, we'll be back next week on Tuesday at 5 o'clock. If we didn't get to your question or you'd like to discuss in more detail, you can always set up a consultation with us or any of our attorneys by going to rnlawgroup.com. You can schedule your appointment online. And Rahul also does a daily conference call on Zoom where you can join that every day, very similar to what we're doing here and answering your questions through Zoom as well. So please feel free to visit rnlawgroup.com for that information.
Thank you.